case law. We try to apply it in a responsible way for our users, but also respecting the fact that the vast majority of legal process we receive from government entities is part of a legitimate governmental investigation. One of the things we've done, in addition to kind of these internal policies in our interpretation of case law, is we've tried to shed a little light on this world, at least how it applies to Google. And a couple years ago, we started to publish some of our statistics about the legal process that we receive. If you go to google.com/government requests, you'll actually see some statistics, not only about data disclosure, but also removals. So sometimes we're ordered to remove content from our site, bring down a YouTube video, take down a blog, remove something from the search index. We publish statistics on that as well. This is a little snippet of it. This is U.S. legal process that we've received over the last couple of years. They're kind of raw numbers, and we're always trying to work on granularity to make the information a little more usable, but it actually turns out to be harder than it seemed when we started this process. But you'll see in the second half of 2009, U.S. demands, and that's like search warrants and D orders and subpoenas and civil legal process from government entities. About 3,500 pieces came in that 6-month period. It went up to 42, almost 43 in the next 6-month reporting period, which was the first half of 2010. So you start seeing a little bit of an increase. In the second half of 2010, we decided we'd like to actually break out not just the number of legal process we received, but how many users were actually at stake in the legal process. One of the things we saw as a limitation on the numbers was that it was fine to count the number of subpoenas and search warrants and all, but oftentimes you'd get a search warrant that had 50 user IDs in it, and another search warrant which would have 1 or none. It might be a search warrant that was indicating a Twitter account that they had sent to us by accident, and so there actually wasn't any Google identifier in there. So recognizing there was a limitation there, we started tracking the number of accounts that were aggregated, that were included in the legal process. So starting in the second half of 2010, we included that statistic, and you see that there was about 11,000 Google accounts during that period which appeared in legal process and for which we were being asked for user data. We also decided that it would be interesting. Yes, sir?
Richard, how does this break down? Is this federal and state, or just, you said U.S., is this combined?
This is federal and state and local and any government entity within the United States. That's right. And I should also say this includes legal process that we received through treaty process from other countries. So if Canada used the MLAT process, the Mutual Legal Assistance Treaty process, to get U.S. legal process on us, that's included in these statistics.
Do you have any sense of what percentage is federal versus what percent is state and local?
You know, that's a breakdown we'd like to do, and we haven't done it yet. So that's actually what I was hoping to hear today, is some observations on what else might be useful. And that is one way to do it. And we've also been thinking about maybe breaking down by type of legal process, so you can see how many search warrants versus court order versus subpoenas, et cetera. The vast majority of this is subpoena. It's not search warrant. Most of this is subpoena. But we haven't published statistics, so we'll have to do some better tracking to be able to do that. Yeah.
Richard, does this include outsiders for preservation? And do you do any tracking on outsiders being converted to follow the process?
This does not include mere preservation requests.
You might want to explain.
Oh,
just
I
for
will.
people who don't know
So
what
there's
preservation
the gentleman referred to something called an F letter, which isn't quite what it sounds like. To you litigators, it probably means something entirely different. But the 2703 F letter is the legal process, loosely defined, where a government entity can ask a provider to preserve information while they go through the process of getting legal process to compel its production. So it may be early on in an investigation that our sexyboy101@gmail.com is suspected in a criminal activity. They think, the law enforcement official thinks that they are going to be able to show probable cause to get the contents of the email, but they're not there yet, but they anticipate they're going to need that. They're also worried that this user might get tipped off to the investigation and would destroy the evidence. So that law enforcement official can go to the provider and say, would you please set aside this communication for 90 days while we build our case in order to get a search warrant. At the end of 90 days, if they haven't gotten the search warrant, they can ask for an extension of 90 days on that preservation. At the end of that 90 days, that's it. It doesn't have to be preserved anymore. So there's basically a total of 180 days that an official has to be able to convert that preservation into a search warrant to compel its production. These statistics do not include preservation statistics on it. We do track those. That's also something we were thinking about including here, the number of preservations we've received. We did a small sample survey. It's been a year now, I think, something like that, of how many preservations did we receive, and we were talking about Gmail accounts specifically, that ultimately did end up with search warrants for production. And that small sample, which may not actually be representative, but it was our best effort given the resources we had. Well, let me ask, how many people think that the number of F letters that we received turned into search warrants for production was greater than 50%? Any hands? Okay, we got one. Less than 50%, I assume, is everybody else, or your, how about under 30%? Yeah, it was roughly 25%. So 1 in 4 actually turned into legal process for production. So at this moment, I'll take an opportunity to rant a little bit that it actually is expensive for us to preserve. It's very easy to issue a preservation letter, and the preservation letter can be very broad and can say, please retain this information, and only 1 in 4 actually gets turned into legal process. There may be legitimate reasons for that, but that is a process that we probably in the future will be capturing through this. The numbers also are a little, or could be misleading in one way around the accounts, the number of accounts. These aren't necessarily unique accounts. So our sexyboy101@gmail.com account may be of interest to law enforcement agencies around the United States. And we got sheriff's departments and consumer protection bureaus and the Bureau, FBI, all asking for information about this user. But each one of those legal process with this user identified in there will count as one account. So we don't deconflict where there are multiple accounts. So this number of accounts is probably lower than that. And I should say this includes not just Gmail, but legal process about YouTube users or Blogger. There's a lot of properties and companies that Google's involved in. And these numbers are meant to cover all of those. In 2010, the latter half, we also started reporting on the percentage of instances where Google provided at least some data about the user. So the numbers are pretty high, 94 and 93%. That largely represents the fact that most of the legal process are subpoenas, and that there was some amount of data that was disclosed. It doesn't mean necessarily that all the data was disclosed, and it doesn't even mean we didn't object to the legal process. It can be you produce some information that's appropriate under the legal process and withhold the rest and fight it in court. So the 93 and 94 doesn't actually say, oh, we just turned it over and there was nothing more to it. Yes, Susan? Well, for subpoena, the question is if it's subpoenas, what are we generally giving out? That's actually, you just look at the statute, as you know, and it actually identifies the type of information available on a subpoena. So it's really basic subscriber information. So the name that was provided by the user when they created the account. So we have many, many Mickey Mouse disclosures. The IP address of the account when it was registered, that kind of stuff, like basic information. Not the detailed transactional stuff of what did this user do on the system, right? That requires the D order that Paul and Kevin were talking about, and certainly not content that's held by Google. So it's basic subscriber, trying to identify who is it that sent this email claiming to have been mugged in London, or some phishing malware that's being sent. It's who is it that is behind that account.
How long does Google generally retain the information? Like when you said it's expensive for you to retain it when you get the F letter, how long would you ordinarily retain it?
Well, yeah, that's that's actually something that's actually nice about the statute is that after the 180-day period expires, if there has not been a legal process commanding the compulsion of the production, you can get rid of it. So it doesn't have to hang around. So the statute allows for getting rid of it at that point.
I think maybe the question is, how long would you retain it if not for the preservation
right.
letter? I mean, and I guess that turns on which type of data we're talking about.
I'm not sure
So
I
how-
understand the
Yeah,
question.
go ahead.
How long would you have kept the data absent the preservation letter? Or is it a matter of taking it from the form that it would normally be stored in and making it in a producible, putting it into a producible fashion?
Well, we wouldn't, absent a preservation letter, we would do nothing with the data. I mean, it's just in its natural form as a service provider. So nothing that happens to the data until we are presented with a preservation letter. At that point, it's set aside for production. But right up until that point, it's just business as usual.
So if I did a search, a year ago, would you have a record of that?
Oh, I see what you're asking.
Yeah,
You're
yeah.
talking about general
That's
business
right.
practices
That's right.
on the retention of records. Boy, I'm not qualified to answer that question. I think we have some publicly available discussions of how long records are kept and how long they're anonymized, but it would be treacherous for me to get into that because I'd probably get that wrong.
The short answer is, I mean, you keep all queries forever. It's just a question of to what extent you've anonymized them.
There is an anonymization, but Kevin, you may know
Yeah.
more about it than I do, so. So part of this is to shed some light on this. We're looking at ways of breaking the data down to be more granular. We've got two issues we have when it comes to granularity. One is that if we get too granular, we start losing the aggregation aspect of the data, and it starts to reveal information that could be bad for the users, like if it gets so granular that you actually start exposing users, or it could be so granular that it starts exposing law enforcement investigations themselves. So that's part of the reason why we chose to go 6 months periods as opposed to every week we publish statistics or every month that we pushed them out. Because you could suddenly see a spike in some month, and if we started publishing what jurisdictions it was coming from, you could suddenly be exposing something that none of it in this room really would want to have exposed. So we're trying to get like the sweet spot where the statistics are useful but also not damaging. We'll be having our next 6 months coming out here pretty shortly. And it's good, the more of this we have, the more useful you can start really seeing trends that aren't just going to be glitches in the numbers, but the trends already you can see, it's definitely increasing year after year. There can be lots of reasons for that. We have more users. It may be that law enforcement is getting more used to using the type of legal process needed to be able to compel production from providers. There's lots of potential reasons. As we get more and more statistics out there, I'm looking forward to all the PhD candidates trying to draw correlations with the price of oil and global warming and all sorts of other spurious causation arguments being made. But we do hope to get these things a little more granular as we go out the next couple of years. I guess I'll spend just a little more time on the Digital Due Process Initiative, which is the effort discussed about reforming or updating ECPA a little bit. You've heard about the efforts to get rid of the 180-day rule, where if it's an old email, that a subpoena is sufficient under the statute to compel its production. Again, I think there's Fourth Amendment arguments that say that's not right, but the statute says that. And part of the Digital Process Initiative is to fix that rule. But there's a couple others I wanted to briefly mention as part of updating the statute. One is, as Paul mentioned, to give some real judicial review over applications for pen register trap and trace devices, the real-time capture of non-content information. And there's another proposal by the Digital Due Process Coalition that addresses an issue that may not be obvious to you. But you can imagine a subpoena being issued to a provider that says, give us the basic subscriber information, just those data elements that the statute says you get with a subpoena, the subscriber identifying information, for all subscribers who satisfy this criteria. And they set out some criteria, but it's a rather broad criteria. And even though it seems like it's subpoenable material, because they're only asking for the particular data element specified in the statute, they're asking for that information about all users who fall in a particular class. That can be awfully broad, and it implicates privacy concerns beyond, I think, what Congress had in mind back in 1986. So one of the things we're suggesting is that the statute, in those kinds of cases where there's a request for a large information about a large class of users, that there be some judicial review before that be granted. So similar to a D order or a search warrant, getting it in front of a judge. And I want to leave time for Paul, so I'll wrap up with that observation on the Digital Process Initiative. Thank you.
And as with before, any questions specifically to Richard about this topic, about Google? Yeah.
Can you give an example of the latter, like what sort of class-based information they might be seeking within the...
You have one, Kevin?
I got several.
Yeah, you hit
One that EFF was involved in was a subpoena to the political news site indiemedia.us, which asked for the IP address of every single person who visited the site on a particular date, which obviously implicates the freedom to read of thousands upon thousands of people. Another, at this point, routine investigative technique is cell site dumps, where they obtain information about every single person who contacted a particular cell phone tower, in the vicinity of a crime at the time of the crime, which implicates the locational privacy of thousands of people. And I believe we've heard anecdotally of subpoenas to eBay in relation to tax obligations, trying to identify people who are selling stuff without paying tax on it, such that they are asking for information on like everybody who sold something who's from a particular jurisdiction. So those are just some examples of mass requests that implicate, and one could imagine, give us everyone who searched for a particular thing. We have not seen that. I don't believe we've seen anything like that, but one can easily imagine it, and that too would implicate the privacy of many, many people.
I actually have a question, a big picture question. So Google actually does compile certain information for business purposes and advertising purposes, what have you. Is there any discussion within Google about the fact that Google's kind of compiling of that information to the extent that the government then comes back and says, well, you have it anyway? Does it in any way open up a philosophical question that the acquisition and compilation of that information in and of itself creates avenues for the government to seek additional information because it's just available, it's just there?
Well, I mean, I don't know if it changes the nature of the question, because it's still what the government is getting after would be the material itself, in which we have, whether it was used, it was also part of the automated system to provide advertising to the user in their account or something. I don't think that actually increases the data sets that are available. But it certainly is a concern, on any sort of product development process that's going on at Google. Part of the question there, as part of a larger privacy analysis, is what is this doing as far as data sets we have that might be exposed, and not just to government, but in all sorts of other contexts, to outsiders. That's right.
All right, thank you. Save your applause in the end.
Oh, and I looked it up. So it's there's some level of anonymization, weak anonymization at 9 months, and stronger, but some would still argue not very strong anonymization at 18 months of your search queries for Google. So.
There's no such thing as strong anonymization.
He's done a great deal of work on this.
I've heard this before. I'm sorry you're getting so much of me today. I kind of feel a little sheepish about that. I will say that there's a grand tradition at conferences like this to put the industry guy up in front of a microphone and then try and trap him into revealing information. So I'm sure there are a few people in the room who'd rather we just did that for another 20 minutes with Rick. So partly what I'm doing is helping my old friend by talking about something else. And for those of you who are in the betting pool, Judge Smith's name has now been mentioned 13 times, so if you bet anything above 13, you're still in the running. So I really am doing kind of an academic move here. I'm going to talk about something that's ostensibly about what we're talking about today, but it's going to be very different. You're not going to hear much from me right now about the 180-day rule. And it is something that Susan has now convinced me to try and write up in the law review. So I'm really excited by this opportunity to air this, but it is going to feel very different from what we've heard. I think at this moment, ECPA reform has become a question of when and not if. I've already talked about some of the reasons why this is the case. We've now got the Warshak opinion. I think it's somewhat of an embarrassment that a fundamental piece of the legislation that protects your privacy online has been declared unconstitutional. I think if for no other reason, Congress should feel some great motivation to try and fix that. But more specifically, I think the work of the Digital Due Process Alliance, which you will hear a lot about right after lunch, and specifically the really, really hard work being done by Jim Dempsey, first and foremost, but lots of the people who are at this conference in addition, have really generated some momentum and excitement on the Hill. Now, this may not be the year for it. I mean, maybe Congress will do nothing else for the next, until the election, but I think it's a matter of when, not if. I also have to say one other thing, which is by way of slight confession. I signed on to digital due process very early. I used to call in, but life intervened, and I haven't called in a long time. I am still a staunch supporter of the effort. I think the Leahy bill is a wonderful idea. But the confession, which isn't really that much of a confession, is the only public thing I've ever written in scholarship about ECPA reform proceeds from the argument that at the end of the day, the signature achievement being sought, probable cause in a search warrant for all content, will not change your lives very much. Now that might be a kind of confusing thing to say. This isn't the focus of my talk, but I wanted to start by playing out that argument a little. The argument I make is that given some particular features of the internet and the cell networks and the way they operate, information tends to come to the police so deeply contextualized that they always have probable cause for the next step, right? The cute way I put it in the article is IP addresses don't suggest that this is a man with a mustache that we must find. Instead, IP addresses and email addresses say, if I get the next hop, I know that it's going to get me closer to the criminal. It may not get me all the way, but it may. Okay, so if you're thinking actively about this argument, you're probably thinking, no, I can come up with 1,000 hypotheticals where the police might engage in phishing expeditions, and we've heard about some of them. And so my article says, look, I'm not saying this is a rule of the world. I'm just saying it's a prevailing tendency of the way internet investigations tend to go. So my prediction is if we woke up tomorrow in a world with probable cause required for all content, it's not really going to bother the police very much. They're going to have to spend more time at the word processor because a warrant is harder to kind of articulate and defend than a D order. But short of that, it's not. Now, here's a key thing I have to say at this moment. It will prevent future prosecutors from coming up with new schemes that end up looking like phishing expeditions. And for that reason alone, I think we should make the change. But I've tried to kind of put a little cold dose of reality on how monumental this change will be. Right? We'll wake up feeling a lot better about our privacy, but I think the same people are going to be investigated at the same steps around the same time. And what we're really doing is we're preventing the crazy prosecutor who is about to be elected 2 years from now from engaging in something much more divisive, and that's much more threatening, and that's an important goal. So today my goal, yes, Stephanie.
Well, just to make clear, you're making that argument in terms of content.
Yeah. No,
Not other forms.
non-content too. I make that argument across the board.
Probable cause.
Yeah, absolutely.
All of that non-content.
And my argument isn't just a thought experiment. I also do a little bit of lightweight empirical proof. And the key piece of proof for me is look at what happened post-Warshak. So the Department of Justice is an agency that every time it feels like its authority is being threatened, marches directly to the Hill, knocks on a door and says, you've got to change this now, right? So those of you who remember, what was the name of the Bach Case, right? The Bach Case was a single magistrate judge in one district who said, you know what, FBI, you no longer can serve your ECPA process by fax. You now have to get on a plane and fly out here and deliver this. Department of Justice, and I was a member of the Justice Department, went straight to Congress and said, this is an outrage. This is the end of humanity. How dare you not let us use our fax machines? And they fixed it in legislation. DOJ is very, very protective of its turf when it feels like it's threatened by adverse judicial opinions. They never, as far as I know, in the last year they've started to ramp it up a little bit more. They never made a public speech against Warshak. They never, floated aggressively legislation to undo Warshak. Why? Because it's my theory that if you're a AUSA in Ohio post-Warshak, no big deal. You still have probable cause. you're now annoyed that you have to spend more time. And again, cold dose of reality. Look, I want to put up my argument out there, and so I'll leave 5 minutes at the end if you want to challenge me on this, but this wasn't supposed to be the purpose of the talk. So, okay, here's the thesis of my talk for today. This is actually much less controversial, so let me do it rather quickly. What I observe is that every attempt to fix ECBA has focused on inter-branch solutions. We want to find ways to cabin the power of the executive by, for example, introducing more authority and discretion for a judge, more public reporting to Congress, more kind of secret reporting to Congress perhaps, but we've really used the kind of Federalist Papers, Madisonian separation of powers as our key tool. And what I want to suggest, especially now that I've been a little bit, not even critical, but pessimistic about inter-branch approaches, is that we should consider novel intra-branch proposals to protect our privacy a little bit more. So wholly within the executive branch, I think there are opportunities to guarantee our privacy more. These slides are not very serious. They're more to just punctuate points, but I have an alternate title here, which is to reform ECBA, put EC in charge of everything.
Oh, no.
Some of you get the joke. EC refers to Mark Eckenweiler. He's a career prosecutor at the Justice Department. I'm going to talk about him and show his picture in a little bit. Okay, so this work builds on the work of a very important, I think, former professor, Neil Katyal, who was at Georgetown and then became the Deputy Solicitor General, the Acting Solicitor General. But before he did that, he was focused a lot on the war on terror and his perception of all of the abuses that were being committed at the hands of the executive branch in order to prosecute the war on terror. And what really disturbed him at the time, and in 2012, it feels strange to think about this, but what really bothered him was that in a time of single-party government over two of the branches, the legislature was just rolling over, that the check and balance of legislative control over the executive had vanished. And so we get the NSA wiretapping program, torture, rendition, Guantanamo, military commissions, and in almost every case, Congress comes along and puts its rubber stamp on it. What Neil Katyal said in this paper in the Yale Law Journal was, if the best version of checks and balances, interbranch, wasn't doing enough, let's think about this new novel form of a second best check, intra-branch. And what he really wanted to do, let's just cut to the chase, he wanted the State Department at the table more often. He wanted the Department of State, the Secretary of State, sitting there alongside the Defense Department every time a new proposal was made about the war on terror, to at least give the president a second opinion. The funny thing about what Katyal does, though, is he talks not just about the Secretary of State, he pushes down into the different agencies. And his article is really this very eloquent celebration of a word that is always otherwise reviled, bureaucracy. His argument is, sure, you think of bureaucracy as something that we try and overcome in a modern state. Sure, you think of it as something that's responsible for delay and obstruction. He said in his experience, and this is my experience too, what we're really talking about when we're talking about the federal bureaucracy is a core of civil servants. And many of those civil servants are in a position that we should all think is somewhat superior to their political masters that we might take advantage of. So let me just play some of the arguments. He said the bureaucracy is not beholden to the particular administration. That's obvious. Oh, by the way, I should show some of my silly slides. So this is the Smiling Bob guy that was at the heart of the Warsaw case, and here's Neil Katyal. Neil Katyal probably isn't happy that I put him right after Smiling Bob. The civil service has specialized expertise. The civil service can take a long view because they're not just thinking about the next election. He just points out that there are just positive redundancies. This is why we have a bicameral form of legislature to begin with. Two people are often better than one when it comes to decision making. He quotes the famous homily, where you stand is a function of where you sit. And so just by giving someone a slightly different worldview, international relations, instead of war fighting, you're going to come up with different things. He cites the laboratory idea that we get when we talk about our federalist form of government. He talks about how the civil service may be less likely to be captured by special interest groups. His paper actually is very different than mine, and I made it available in the CLE materials because his paper focuses, as it should, on the war on terror. on how could you possibly structurally build this in. Secondly, how could you make sure that the president wasn't just bypassing one set of advice in favor of another? Now, as I cast my attention from his view on the war on terror to law enforcement uses of procedure to get our private information from the internet, the interesting thing is this all typically happens at the federal level in one agency, in the Department of Justice, right? Sure, there's some work in Homeland Security through the Secret Service,